It's a pleasure to be here. I wanted to talk about the criminal law aspects of data breaches, and I wanted to break that down into two different parts. The first part is what kind of substantive crime laws could be brought, could be charged in a data breach case. It turns out there are a bunch of different criminal laws that apply to various degrees, different degrees of clarity and different degrees of punishment to data breach investigations. This is focusing on the individuals that are obtaining the information or using the information, not the companies that may have bad security practices that may be subject to some sort of civil enforcement but not criminal enforcement. And then I wanted to talk about the investigation side of these sorts of cases and the difficulties that criminal investigators have trying to catch the bad guy. So it's all well and good to have the criminal laws on the books, but if it's impossible for the government to actually find who's engaged in the fraud or who's engaged in the unauthorized access, then those laws don't really do a whole lot. To sort of summarize where I'm going, there are a lot of different criminal laws that apply in data breach cases, but it's very difficult for the government, generally speaking, to find those primarily responsible for the breaches. So the difficulty really from the enforcement of criminal law is finding the people responsible, not finding laws to punish them once they do. So in terms of the substantive criminal laws that could apply in data breach cases, there's a host of different laws generally focused on different stages of the data breach. So for example, if you sort of break down the pieces of a data breach, it might be the initial access of the information. Somebody who's not supposed to have access to the information gets access to that information. Then there's usually some sort of distribution of that information, sending it to, say, a server somewhere or distributing it to somebody else. Then there's some sort of use of the information or attempted use of the information. In the case of credit card information, somebody might engage in the fraudulent use of the credit card. And each of those stages has a different set of legal criminal laws that might apply. So the first stage generally is covered by unauthorized access laws. The federal government has an unauthorized access law, and all 50 states also have such laws. They generally prohibit access without authorization to a computer, and in some cases also exceeding authorized access to a computer. And those statutes generally apply to any sort of unauthorized access to any computer, not just unauthorized accesses that involve sensitive information or particularly valuable information. The difficulty in interpreting those laws, some of the cases are easy, some of them are hard. The outsiders that come in, guess a password or use some sort of method of resetting a password, those cases are very clearly covered by the unauthorized access laws. It is an access without authorization to gain access to someone else's account. That's sort of the clear case. The difficult cases that the courts are still grappling with is what to do when there's some sort of an insider who's gaining access to the information first, because you'll have, say, for example, an employee of the credit card company who, for work-related reasons, has access to the files. They then are working with somebody else to get a copy of those files and use them for some nefarious reason. The difficulty the courts have is trying to figure out is that unauthorized access or not, because the access may be authorized but then the use is not authorized. And the question that the courts, even just as recently as a few days ago in an important decision from California, are trying to grapple with is, does that count as exceeding authorized access or not? The difficulty that the courts are having is that although it's understandable why you would want to punish misuse of credit card information, for example, an employee of American Express who's trying to gather the information and then distribute the information to somebody else so it can be used for illegal reasons, it's understandable why you'd want to punish those individuals. The difficulty in interpreting the law comes because if you say that that's a crime, isn't it also a crime to violate terms of service of a website? You probably violate terms of service of a website every time you surf the web. Looking, for example, at the terms of service of Facebook, every piece of information you enter has to be accurate. I know on my Facebook page I say I live in Washington, D.C. That is a bald-faced lie. I live in Arlington, Virginia. And so I'm technically in violation of Facebook's terms of service. And so what's the difference between saying violating the terms of access to a computer in the case of Facebook servers versus of an employee of, say, American Express who's violating the restriction placed on their machine. You can only use the American Express computers for work-related reasons. So what courts are grappling with is what to do with the case of the insiders who have access but then are restricted based on some sort of written term in terms of what they can do with the account. And right now the circuit courts are just divided on whether that's unauthorized access or not, and probably the Supreme Court will try to figure this one out in the next year or two. But that's the first set of laws, the unauthorized access laws. Those are a bunch of laws which go back to the 1980s and have been used to try to deal with computer hacking and unauthorized use of accounts. So that's one possibility. Another possibility, which is more directly focused on the types of problems as we saw in the breaches of credit card information, are the credit card fraud laws. There's a statute called access device fraud, and it deals specifically with credit card fraud. It criminalizes all sorts of activity relating to misuse of credit card. It might be trafficking in stolen credit cards, use of stolen credit cards, possession with intent to use stolen credit card information. It's kind of like modeled in a lot of ways after the narcotics laws, in the same way that you can have possession with intent to distribute cocaine, you can have possession with intent to distribute, or possession with intent to use fraudulent credit card information, same basic concept. So that's another regime that's sometimes used. There are fraud laws more generally. Any interstate fraud is prohibited by federal law. So somebody who's has a plan to take advantage of a stolen credit card is going to be liable not only for the access device fraud, but also just for general wire fraud. Interstate wire fraud will cover that as well. And there's some other crimes that are out there. They all end up sort of being treated in roughly the same way by the sentencing guidelines in the federal criminal justice system. Most sentences are determined by the sentencing guidelines, which have a relatively complicated structure for figuring out how severe should different punishments be for different crimes. And there is one provision of the sentencing guidelines that's focused on economic crimes, and the key determinant of the punishment is how much loss was caused by the act. So in data breach cases where there's a tremendous amount of valuable information that has been taken, but quite difficult to determine exactly what the losses are, whether it's the value of the information or the subsequent downstream losses based on the use of information, the courts really grapple in those cases with trying to estimate what the loss is. And a lot of times they're saved by a plea agreement in which the government and the defense get together and say, we will stipulate that the loss was in a certain range, and that way the judge does not have to try to figure that out themselves. If they do have to figure it out, they'll have a hearing and have experts on both sides, and then just sort of make the best estimate that they can. So that's what the substantive law looks like. To summarize it, there's lots of different ways that the data breaches can be criminalized or have been criminalized, and there's lots of punishment generally based on the size of the economic loss caused by the data breach. The harder problem from the standpoint of law enforcement is finding the people responsible for a bunch of different reasons. So from a law enforcement side, generally it will start with the intrusion itself. Hopefully the intrusion left some sort of clues as to where the attack came from. If we're talking about an attack over the internet, where perhaps an IP address of where the intrusion came from might be available. And then the difficulty becomes trying to trace back that IP address hop to hop to try to find who was actually responsible for the conduct. It's enormously difficult, as many of you can recognize from just a technical perspective, because first of all, attacks can be hidden. They can be routed through locations where it's impossible to trace back where the attack came from. Maybe it was through a Tor network, goes into the network, and it's basically impossible for law enforcement to trace it back after that. At least sort of ideally the law enforcement practice would be to go to the prior hop and say, was the attack coming from here, or do you have records of the attack? And in those cases, if it just so happens that somebody hacked directly into the victim, then it's an easy case for law enforcement, but it's much more common for people to try to hide their tracks. Tracks can be hidden not only through the use of some anonymizing system, but also simply using a server located outside the United States will make it a lot more difficult for U.S. law enforcement. The IP address on the net could be anywhere, it doesn't matter geographically where it is, but from an investigative perspective, if you're a Los Angeles Police Department officer and an IP address goes back to France, you don't have jurisdiction in France, so you need to find somebody who's willing to help you. Generally, it'll go to the federal level. The federal authorities can work with the French authorities, but it becomes much more difficult simply to trace back the attack because the law enforcement jurisdiction, of course, is rooted in the physical world and in the physical concepts of sovereignty and territoriality, not in the virtual world. So it's very difficult for law enforcement to try to find who's responsible for these sorts of intrusions. Often what happens is that the people who sort of masterminded the attack are not caught, but then somebody who uses the accounts might get caught. There's sort of various aspects of the offense, some of which are more visible, some of which are less visible to investigators. So it may be that the initial access and obtaining the information and distributing the information is something that law enforcement can't trace, but some downstream sort of low-level offender buys the credit card, stolen credit card numbers, tries to use them, and then it's that use that then leads to criminal investigations and charges. So there's some criminal law investigation that is successful related to it, but it's very hard for the government to investigate the poor offenders. And my sort of rule of thumb in these sorts of cases is the government generally can catch the dumb ones. If you're really sophisticated, or even modestly sophisticated, usually it's pretty straightforward to find ways, unless you slip up or decide to tweet your attacks, or put them on Facebook, or have a picture of yourself, post it on the web, then it's pretty relatively good chances that you'll avoid criminal prosecution, unfortunately.